you doing?
I'm doing great. How you doing?
Terrible.
Too old?
57, yes, sir.
Pretty young.
On behalf of Mr. Stevenson, who was approaching, Arne, when you get to the podium, state your name for the record.
Well, Rondé Anderson. Thank you. What are we doing?
Your Honor, we're asking for an adjournment in this matter. We were prepared to set it, but the people have informed us that they don't discover your comment or jail comments.
I'll adjourn it out then to July 16, 2026. Man.
That Mr. Anderson had a call for the visit from jail. He was calling her before arraignment from his clinic. And then after he was arraigned, he made 2 more calls to her from another thing. I have concerns given that in the most recent lengthier call that was about 7 minutes, he says to her, my friend doesn't come. If my friend doesn't come, I'm going to get a motion dismissed because the victim ain't coming. But I don't know if they're going to do it or not that day, but hopefully they do dismiss it. And I have concerns in saying these kind of things to the victim in this case. I also have concerns with the facts of this case that could potentially be to, in addition of an A1 charge at exam, given the nature of the strangulation and the threats that he was saying to the victim while he was strangled. So at this point, I'm going to be asking that his bond be raised to our original request of $100,000 cash surety rather than $50,000 cash surety, given that he violated the bond from the jail.
Your Honor,
I already revoked his phone privileges. Pardon?
Your Honor.
All right.
Your Honor, in regards to the phone calls, I'm awaiting the calls from the people. Ms. Enna states that she'll get those over to us. I did speak with my client prior to knowing about these calls. He absolutely knows now, especially after my conversation with him, that
He didn't understand the magistrate.
well, I can't necessarily.
Magistrate Keller speaks in very clear English.
I know.
But go ahead. I'll let you go with your argument.
So, Judge, we're asking that he still be allowed to, I don't know if there's a way that they can block the complaining witness's telephone number. He reports to me that he does have other numbers. He has a child, a 1-year-old child who, at the time that he was arrested on this matter, was in the hospital in critical care. He has desperately trying to find out any updates on the child. It's not the child that he has in common with the complainant in this matter. It's just another child of his. So he needs to be able to at least communicate with his family members to check up on the status of his child. Initially, we were going to address bond today. Obviously, I know the court is not going to approve any reductions to his bond amount due to these new calls that the people will have presented. I have spoken with the people in regards to a potential for an agreement to a release treatment. Have expressed that they are not in agreement to that whatsoever. We would still present that to the court. Something that we've discussed, and my client does admit that he is coming to the realization that there may be some substance abuse issues that he needs to address very quickly. So we wanted to see if the court would at least consider allowing him to be released to an inpatient treatment facility on a tether. I've explained to him exactly what that looks like. He is prepared to do that if allowed. We'd ask that the phone privileges not be revoked so that he can communicate with his family. I don't know how we can isolate that of the complaining witnesses' communication or phone.
Why would I do that if he has already abused the process? I mean, I hear you, but I don't even understand any logic in me doing that.
Only because of his ill child, Judge. That's the only thing that would differentiate this from any other case where somebody has abused the phone process.
People's motion to raise the bond is granted. I'm going to raise this bond to $150,000 cash as surety. The defendant's phone privileges as well as texting privileges are hereby ordered revoked. Thank you.
Thank you, Judge. Anything on the release to treatment?
I will not order release to treatment.
Okay.
I don't know that he would cooperate in that process. And if he got out, we back because he can comply with anything else. Some simple things.
What just
Thank you.
happened is more significant than a routine bond ruling. The prosecution wasn't simply arguing that the defendant violated a court condition. They presented allegations suggesting he used jail communications to influence the progress of the case. From the judge's perspective, that creates a public safety concern and raises questions about whether the defendant will comply with future court orders if released. Notice that the defense never really disputes the existence of the calls at this stage. Instead, counsel shifts to mitigation, explaining the defendant's family situation, his child's medical condition, and proposing inpatient treatment with electronic monitoring. Those are understandable arguments, but they don't directly address the court's primary concern: trust. Once a judge believes a defendant has abused privileges already granted, requests for additional flexibility become much harder to justify. Did you notice how Judge Simpson focused less on sympathy and more on the defendant's conduct? That's often a key distinction in bond decisions. The court isn't deciding guilt here. It's deciding whether the defendant has demonstrated that court-imposed conditions can realistically be trusted going forward.
Thank you.
Thank you, Judge.
Court does call the case. People versus Michael Brown.
As it always is.
Oh, really? Does he want it revoked? You know what? Tell you what, go talk to your client. Tell him my offer to him is to have his bond revoked. If he wants to keep talking, I'll bring him back out and let him know. I'll wait for your reply.
Assistant Public Defender Deputy Mr. Brown. Brown, put your name, please.
Brown said, I want to be up here now. Go
I was thinking that, Your Honor, we are requesting an adjournment for some investigation. Then I think 2 weeks would be, please.
And are not opposed to the request for an adjournment. I will let the court know he has another case up next week.
Oh, he has another case up next week.
I have the case number if the court wants it. I just don't see the point in coming back like 3 weeks in a row.
Got it. You know anything about the other case?
Yes, Your Honor, I'm handling that matter as well. I would have no objection to moving it to the same date. I think the information we're gathering would be relevant to that as well.
Okay, let's do this. Then I'll adjourn this one to the 23rd. We'll also get that other file, and I'll just adjourn that to also the 23rd.
Thank you.
All right.
The help 26 at 55070. July 23rd. Thank you, everyone.
Thank you, Your Honor.
Thank you. Court does call the case. People versus Nicholas Coots.
President Elvis with a few moments.
Assistant Public Defender, your deputy lead. Shoot. Remember, we'd be requesting adjournment in order for body camera. Would also like to address bond.
Your name, sir?
Nicholas Coots.
All right. What as to bond?
And with regard to bond, we'd be asking for a release to treatment. Mr. Coots explained to me that
Any objection from the people? All right. Just file the order.
yes, Your Honor.
I'll be more than happy to do that. I'll turn this matter out to July 16, 2026, 9 a.m.
Thank you.
Court calls the case. People
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender representing Mr. Bailey.
Your name, sir?
Tony Bailey.
Thank you.
How you doing?
I'm doing great. How you doing?
Terrible.
Okay, me too. It's hot out there though, but
I'm too old to be even standing in front of you.
too old?
57, yes, sir.
Pretty young. All right.
Don't you remember I sent you some artwork? You forgot. Okay.
No, I don't forget any, but that I forgot. All right.
It's on YouTube. Tony Bailey, straight jacket, short bus with a football helmet. You see the artwork.
Okay.
and my music.
Okay. I'll take a look.
Hey,
What are we doing?
Your Honor, we had proposed a resolution to the prosecutor. At this time, they are not open to that. We're requesting an adjournment for some additional time to discuss the options.
I'll adjourn the matter out July 23rd, 2026, 9 a.m. Will that work for you, sir?
Yes.
Or you going to be too old on that date?
It's 27.
trying to go to the hospital for my injury. From this.
You guys keep talking and probably be that date by the time we go.
Your Honor, he's asking for some, if possible, some additional time. He has to go to the hospital for some injuries. So maybe 30 days.
August 6th.
Thank you.
Thank you, Your Honor.
You're welcome.
Have a nice day.
You do the same.
Right.
Okay.
T-Bone. What?
Yeah, that's my name.
Is it? All right, T-Bone. Have a good day.
Ready to go for the deal.
You made quite an impression for 45 seconds.
Good morning, Your Honor. Robin McCoy on behalf of Mr. McKinnon, piece number 63057. I do apologize for the delay. We've got a lot going on right now. So,
Okay. Your name?
My name is Makai Nunn, Your Honor.
All right. All right. What are we doing?
Your Honor, so this is set for a PCC. We are still, we've yet to receive the discovery. We did put the request in so that we would probably want to adjourn this briefly. I did file a motion to address bond. Mr. Nunn's mother, Vicki Pearson, and his sister, Michaela Nunn, are present in court with him today.
And
Insurance.
special type.
Yes. Yes.
All right. You're seeking to adjourn this, and have the people seen the bond request?
Your Honor, would you like me to address the bond at this time?
Well, we need. What? Did you file an appearance, Ms. McCoy?
I emailed an appearance and a substitution of counsel.
Okay.
So this was filed last week and it wasn't addressed before. It wasn't filed with the other one.
Did you send over the bond modification request to the prosecutor's office?
We did. We sent it when we first filed it. Initially, we filed it because it came up as 14B. So we did send it. We copied the prosecutor and 14B, and then they directed it over to the court. And they said that the court had read the motion, but that because we were trying to get it in sooner, but they said it would be set for today. But we did copy the prosecutor's office on there.
Right, but but they don't have a copy of it.
Okay, if they have an email, I can
We
send it.
didn't get your appearance until today.
I did. Yeah, I emailed it to the court early on, but the court had informed me that the public defender was listed as the attorney of record. So we sent over the request for the public defender to sign off on it. And we did send that over to the court. I guess the big issue is, Your Honor, is he has had,
the big issue is I don't have the paperwork in order, Ms. McCoy. So you can't overtalk this. I'm just trying to straighten it out so that Mr. Nunn can have a hearing today, to the extent we can. That's the big issue. Did us
File signed in 20th today.
1023, we got the substitution. So today. So that was about 45 minutes ago. Thank you for the math. Okay, I have that now.
This exchange highlights an aspect of courtroom practice that viewers often overlook. Procedure can be just as important as the substance of a motion. Defense counsel is attempting to move forward on a bond modification request, but the judge immediately identifies a procedural problem. If the prosecutor hasn't properly received the motion and the court record isn't complete, moving ahead could create fairness issues and potentially delay the case even further. Rather than denying the request outright, Judge Simpson chooses a practical solution by passing the matter to give both sides an opportunity to prepare. That reflects an effort to protect the integrity of the process while still allowing the defendant's request to be heard. Did you notice how the judge interrupted when counsel tried to explain the client's circumstances? It wasn't because those facts were necessarily irrelevant, it was because the procedural issue had to be resolved first. Experienced litigators know that even strong legal arguments can lose momentum if filing requirements or notice obligations aren't satisfied before the hearing begins.
Here's what I'm going to do. Because you say his family's here, everybody, I'll hear it. Can we get to the prosecutor's office to the extent they can be ready to answer the bond modification motion, and I'll pass it.
Yeah.
Okay. So, Mr. Dunn, I'm going to pass the matter. The motion for the modifying bond was not given to the prosecutor's office. We're going to get a copy to them. We'll bring it back out and we'll address it.
Yes, sir.
Got it. Thank you.
This hearing demonstrates that many courtroom appearances are driven by procedural decisions rather than dramatic testimony. Throughout the docket, Judge Simpson consistently focused on keeping each case moving efficiently while ensuring that both parties had an opportunity to prepare. When requests for adjournments were reasonable and uncontested, the court generally granted them, but when a defendant's own conduct raised concerns, particularly in the earlier bond hearing, the judge responded by imposing stricter conditions instead of relaxing them. That difference illustrates an important legal principle. Judicial discretion is heavily influenced by a party's demonstrated willingness to comply with court orders. Credibility matters, preparation matters, compliance matters. Another lesson from today's proceedings is that successful advocacy requires more than persuasive arguments. Proper filings, timely disclosure to opposing counsel, and following procedural rules all affect whether a judge can even consider the merits of a request. That's why some motions were delayed, not because the underlying issues lacked importance, but because the court first had to ensure a fair process for everyone involved. Looking across the entire hearing, Judge Simpson's approach remained consistent: maintain courtroom order, protect procedural fairness, and make decisions based on the information properly before the court, rather than speculation or emotion. Which ruling stood out to you the most, and do you think any party could have strengthened their position with a different courtroom strategy? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.